Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Okay, it's time to commit. 2024 is the year for prioritizing yourself. Begin your new smile journey with Byte, and you could start seeing results in just 2 to 3 weeks. Just order your at-home impression kit today for only $14.95 at Byte.com. Byte Clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer financing options, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning. This episode includes discussion of the murder of 2 children.
Well, today is a big day in the Delphi murders case. This is January 18th. This is a Thursday. And we have just come from the Supreme Court of Indiana hearing in the Richard Allen case. So today we're going to unpack everything we heard, all the arguments from the different sides, and then discuss our analysis and what we think of the whole thing. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Richard Allen goes to the Indiana Supreme Court. Oral arguments.
So we all know what this hearing is about, what the dispute is about. Basically, of course, Judge Gull removed the original defense attorneys, Bradley Rozzi and Andrew Baldwin, from the case back in October. And so what the case boils down to is, was that proper? Did she exceed her authority? Should a judge be allowed to get in between a person and his attorney?
And is that what happened here?
So the hearing was at the Supreme Court of Indiana today, and I think the first thing worth pointing out is the very obvious point that this is a very different type of court and environment than what we've been used to in the past.
Yeah. I love this environment.
Number one, in the past, when we've gone to hearings related to the case of Richard Allen, they've basically been the center stage of whichever courthouse they're happening in. Carroll County, of course, it would be dominated by, here's the Richard Allen case, here's the hearing. And there was one hearing in Allen County, which, again, it seemed like this was the most important thing going on in the building. But this was different today because the Supreme Court of Indiana doesn't have its own building. It has a portion of the Indiana State House.
Which is beautiful.
The beautiful building is a very large building.
It's huge.
And there was an awful lot of things going on at the State House today that had nothing to do with the Richard Allen case. So it wasn't the dominant thing. There
was a protest for Palestine going on during the hearing. There were families with small children running in and out looking, what's that? Why are all these news people over there? And then kind of hurrying their kids away.
It was State House Day, whatever the devil that means.
There were lobbyists.
There was some sort of organization devoted to doing something in regards to mental health that were throwing some sort of event where they were trying, I guess, to smooth with legislatures and stuff. And so I didn't do it, but I think if I wanted to, I could have stolen a few donuts from them.
But you were a good fellow. You didn't steal the lobbyist donuts. And yeah, it was just interesting because we're so used to being there being such a hyper fixation on Delphi that it's a good reminder that there's other cases, there's other things going on, and that while this is a very important case and deserves attention, sometimes I think people can kind of take into it some of this bias of like, I care a lot about this, so this therefore is the only thing that's going on in the world. We've seen that even like with why hasn't there been a ruling yet, or why didn't the prosecutor do this, or why hasn't the defense attorney done this? It's like a lot. They have other cases. Everybody does, and certainly the Indiana Supreme Court does. And yeah, today was a big day. Oral arguments for a writ of mandamus that asks for three things: for the original defense attorneys, Andrew Baldwin and Bradley Rozzi, to be reinstated to the case, for Judge Frances Gull, to be recused and removed from the case, and for the trial to then happen in 70 days.
Right. And so before we get into the gist of the oral arguments, just so you're all clear about where we were and what we were seeing, we did get a press pass, unlike other earlier court hearings.
Yes, which was nice and better organized than anything else that's happened.
The staff here at the Indiana Supreme Court
They did such a good job. It was very organized, it ran very well. It was streamed. Basically everything you could want in one of these things. There should always be media passes and press passes, because it's ridiculous that there isn't. It's frankly felt, it made me realize how unfriendly to the press a lot of the things in the Delphi case have been so far. And I'm not saying the press is the end all be all, but again, it doesn't help things to have it be so willy nilly, frankly, and having people show up at like 5 a.m. and have to wait around when that's not necessary.
Yes, this worked very, very smoothly, but we got one press pass. So I went in the courtroom and got to hear the oral arguments in person. Anya was just outside the courtroom watching them the way I'm guessing most of you watched them. If you did watch them, she watched them through the live internet feed.
Yeah, they had a monitor out in the hallway just outside the courtroom. And at first I was in a little box. I mean, it was like a little, like, I guess, phone booth situation. I was kind of hanging out there for a while. Then I kind of wanted to be in the mix. So I was at the monitor, but I also had my headphones on so I could listen to it more clearly off my phone. So that's how I listened. So, because, I mean, every outlet got one. So I felt that should go to Kevin because he's an attorney, and I thought he could have a better read on the situation than I could. I think he did a great job. So I think we made the right call.
One more thing before we get into the oral arguments. Let's talk about some of the people there who were not attorneys. Superintendent of the State Police, Doug Carter, was there.
He was there. Jerry Holman of the state police was also there. I believe I saw Dave Vito of the state police as well.
Becky Patty, Mike Patty.
Yep.
Prosecutor Nick McClelland.
Yep.
Andy Baldwin and Brad Rozzi. This case revolves around their conduct and how that conduct should be judged. They were not arguing the case, but they obviously have a pretty big interest in how it turns out.
Absolutely.
They both were there.
And that makes sense. It's important. The outcome of this is important for the case going forward. So to see a lot of these different stakeholders, whether it's the old defense team, whether it's the family of the victims, whether it's law enforcement, makes sense to see different people there showing up and seeing what's going on.
So the first speaker before the court was Mark Leeman. He was arguing for Richard Allen's side. So he's the one that says what happened was improper. Baldwin and Rozzi should come back. Judge Gull should be tossed off the case, and there should be a trial in 70 days.
Yes. And so he's making that case. And I think this started during Leeman's session or time, but certainly continued into later sessions. The justices of the Indiana Supreme Court were pretty feisty with their questions. I think that's not necessarily so surprising to people who have watched oral arguments before, but I myself was a little bit like, I mean, if you saw me out in the hallway and my eyes were bugging out and I was like writing things and like had a very awkward smile on my face, it was because I felt uncomfortable because they went hard at these guys. They were really, these justices came prepared, and that's to be expected. It's obviously a very important job. They're if they just showed up, hey, whoa, who's Richard Allen? That would not be a good sign. But
they pushed everybody.
They pushed everybody. They were pushing people around. They were pushing people's buttons.
In other words, they weren't just being harsh to Richard Allen's side. They were also being critical to the other side.
They were really harsh on everybody. And I think that's good because it's an important case with an important outcome. So you have to press both sides and really make sure that you're coming to the right conclusions. But they started off that with Leeman.
What were some of the moments in Leeman's presentation that stuck out to you as highlights?
One thing that came up was the question of whether a judge can ever do this. So what Leeman seemed to be contending was that the judge didn't do this right, but even if she did, it still wouldn't be right because you can't do this. And I think the justices wanted him to unpack that more. Are you saying under no circumstances can a judge ever remove somebody? So they were kind of digging into that with him and like, what does that look like? And he's noting, well, it should be, if like the examples you give would be for conflict of interest, not negligence. There's a difference in what that means.
Because, of course, Judge Gull said she removed the attorneys or suggested that they withdraw because of negligence. And the closest thing they could come to that to discuss was conflict of interest. And later on, it's acknowledged that nobody could find a case that's exactly like this.
Nobody was able to do that. It's such a bizarre set of circumstances. And with one thing that stood out to me, the Woodhouse leak got indirectly referenced by Chief Justice Loretta Rush, and she indicated that a lot of questionable things have gone on in terms of Allen's original defense attorneys. I think indicating that, at least for her, there's concerns about their conduct in this case. Although we'll get to this, but she also had concerns about what the judge was doing.
Another question I thought that came up from the judges during this portion of the arguments that was interesting was they said, what if we end up agreeing with Judge Gull and we believe that these attorneys are incompetent? Are we still required to put them back on? Is Richard Allen's right to counsel of his choice, in your mind, is it so absolute that we are required to put on and let him continue with what we would regard as ineffective counsel? An interesting question to consider. And then there was a follow-up discussion that they return to frequently, which is, what if we feel that these attorneys are grossly negligent and are going to mess up, and there's a trial, Richard Allen is convicted, would he then be able to file a claim saying, oh, it wasn't fair, I had ineffective counsel?
They really could not get a straight answer from Leeman on that, I felt, and they kept going back to it. And of course, in a situation like this, an attorney does not want to concede anything. You don't want to be like, yeah, we'll waive it, because then that takes off, that could be harming your client down the line, I imagine, if you're like, speaking too loosely about that. That's something we talked about with George Hicks the other day. You don't want to just say whatever you think the justices want to hear. That's going to mess up that's bad, that's bad lawyering. So he's kind of not answering that, and they're pushing him. Because
they're pointing out very sharply and deftly, they're pointing out this doesn't seem fair. That a defendant would be allowed to say, oh, the judge thinks this person is incompetent, I want to keep them anyway. And then if he loses the trial, still be able to say, well, it's not fair because this guy was incompetent.
Yeah, look at all the examples of him being competent, and they still had him be on. It's like, because you asked for him. You can't cry over that. You can't come crying if you want. That's what they're saying. Can he come crying at the end of this?
Yeah, should he have the right to say, oh, I need to have these attorneys, and then if you have these attorneys and it's a problem for him, can he then say, well, I shouldn't have had these attorneys? And they suggested that in a situation like this, perhaps
waive it.
Yeah, make the defendant waive the right to later on say my counsel was ineffective.
It's like a kid who really wants a toy and like throws a fit in the store for it, and then they take it home and they don't want the toy anymore. It's like you have to commit to this if you really want it that badly. I think that's what they're getting at. Leeman was really dodging that. I think he came back around in the rebuttal though and indicated that would be okay. Right. So I think he did close that loop, but there was a lot of back and forth about that. And yeah, they asked him a lot of tough questions. His approach just stylistically seemed more emotional, in terms of kind of like the aggrieved tone. These are the lawyers he wants. These are the lawyers that will do a great job with him. They had such an effective strategy. One thing that I thought was very weak that he said, amidst some strong points that I'm going to highlight in a minute, was that this whole thing about the 70-day trial thing, to me, is just such an obvious, he didn't ask for that. They had paperwork ready to go and they never filed it. That is, to me, just a strategy to light a fire under the Supreme Court. And this is why we're doing this. We have to go to the Supreme Court because his rights are being currently violated. It makes it more urgent. I think that's just a ruse. I think if they come back on, I don't think it's going to happen in 70 days unless they're brought back pro bono, because then they'll essentially have to. Yeah. I don't think that we're going to see that. I just think that's basically something that's theater, in my opinion. I mean, maybe I'm wrong, but I don't really see that. Points that I thought he really did well on were essentially that if you are looking at this from the perspective of, like, how do we determine if Judge Gull did or did not do the right thing, that's very difficult to do because the record is not there.
And he was asked a tough question about that.
Yes.
At one point, one of the justices said, well, wouldn't the record have been better if they hadn't agreed to withdraw? Because Judge Gull had indicated she was prepared to hold a hearing. So are you basically complaining that there isn't a record because, in fact, your guys chose not to make a record? Mm-hmm. And the answer that Leeman gave was, actually, he thinks that hearing had been held that day.
It would have been worse.
It would have been worse because it would have put Judge Gull's opinion in the public record, not only her opinion of counsel, but her opinion of counsel's strategy. And that could have been very, very harmful.
Right. So I thought Leeman, for the most part, maybe a few stumbles, generally was very much thinking on his feet, coming back with good answers, citing for a variety of different things. I thought he did a very good job, in my opinion. That's just my opinion. I'm not a lawyer. I'm not a fancy lawyer like some people here, but I definitely thought generally, I mean, I can't imagine that anybody does an oral argument and doesn't have a few hiccups verbally or like kind of maybe a moment where they're kind of caught off guard. I think it more matters of how you kind of come back from it. And I thought one particular standout for Leeman was he did a very good job in the rebuttal, in my opinion, kind of clarifying some things.
And we'll talk more about that later.
Yeah, we'll talk more about that later. I'm just saying, overall, I thought he did a good job.
Some other points that I thought are worth repeating. He said that in the chambers meeting between the judge and the two defense attorneys, when she was talking about some of the things they did that she found to indicate that they were grossly negligent, he says nothing she cites actually had anything to do with trial strategy or action, and that the leak of the crime scene photos did not really affect or impact trial strategy. So
can you answer my question about that? Because I was kind of confused on that point, and maybe I'm just not really used to legal language, but couldn't it be argued that like a crime scene photo inherently involves trial strategy if they're arguing, well, elements of the crime scene are clearly odinist in nature and that's their strategy, and that is or is not reflected in crime scene photos?
That's certainly.
So I didn't really get that. That just seemed like, well, that's not a big deal. Okay.
That's certainly an argument you could make. You could also make the argument that putting out crime scene photos would potentially inflame a jury. Again,
right.
Or inflame the public.
Which I think is
Richard
true.
Allen.
Yeah. I guess some things it's like a little bit of hand waving, and I kind of I understand that. And also I think fundamentally this comes down more to what the law is and what's less damaging for Richard Allen kind of is at the center of what this is going to come down to. And so it's not like a major point for me, but it's just kind of like I don't know.
I think when you talk about things that do or don't directly affect trial and trial strategy, maybe they're talking about things like not being prepared, showing up, not making motions you should have made, not preparing a witness, or like having a witness and then not knowing what questions to ask them during cross-examination. Mm-hmm. Those are things, if had they happened, would obviously impact the trial. And he's saying nothing that actually did happen in this case directly impacts the trial. He's not saying it's good that the pictures were leaked. He's just saying, I don't believe it impacts.
I think you can make an argument that just from the inflammation alone, it impacts the trial. But I think in terms of one thing he also noted was like, is negligence a standard here? Or like, what is incompetence? Are we even reaching a threshold there? What does that look like? And if we don't have a record to really draw from, how can we say? So you're probably sensing there's a lot here about not only whether what happened, the results rose to the level of like forcing the removal of the attorneys, but also is there even a reason to do that under certain circumstances, and what are those? And if we're not seeing those, should that ever happen? So, one thing I would just encourage listeners is like all this stuff can be confusing. It's confusing to us too. It's one of those things. Nuance is important. You can really not like the fact that the leak happened and still think that ultimately, to be more conservative, it would be better for Richard Allen's rights if he's saying he really wants these attorneys for them to come back pro bono. There's like different nuanced takes, or perhaps, well, I think they should have been removed, but it wasn't done the right way, so perhaps there needs to be a hearing to determine that. Not everything, too much in this case, mostly inflamed by bad actors in new media positions, frankly, becomes like a stupid sports game of like one team versus another. I think if you actually care about justice, having kind of an open mind and having a bit of a nuanced take on these things is probably a better place than to be just agreeing with the people you like constantly. I guess what I'm saying is there's elements in this where I think everybody should be concerned, whether or not you think that the old defense lawyers are doing a good job, whatever you think about the leak. Because if this ends up in a situation where there's, structural error, we'll talk about that in a minute.
Yeah, just a second.
Then that's not good for anybody.
Structural error is basically really, really big error.
It's really bad error.
And in fact, near the end of the first portion of his argument, Leeman said that if you take away a man's chosen counsel, if you take away the attorneys he trusts and relies on, that he believes would do the best job of advocating his case. If you take that away from him and he loses the trial, you've committed an error so grave that it basically renders the trial he has with the other attorneys moot. And it's basically just a practice or a show trial, because a later court would inevitably say this error involving taking away the choice of attorneys was so serious, we need to have a do-over. And Leeman says, no one wants a do-over. Let's just get it right the first time. That's his argument.
Right. A do-over, it would be devastating for families, for the entire system, for the prosecutor's office. It would be bad. There may be an appeal, a successful appeal, no matter what. At this point, I don't know, but it's what he's saying is like this locks us into that, essentially, in his view. And the way the justices were questioning him around that indicated to me, at least, that they took that very seriously. They weren't dismissive. Oh, well, do we have to have an appeal? Because they were even asking questions like, well, would he waive appeal around incompetent counsel if we brought them back? So that tells me that, okay, they're trying to understand what the options are. One thing Loretta Rush kept saying was, how do we get this case back on track? She wants things back on track. She wants things proceeding smoothly. And so I got the sense that for her, this is not just about, this specific issue, but it's about what is best for the case in the long term. And of course, they're also thinking about macro issues like, how will our ruling affect our caseload and other criminal cases? And, just if a similar situation pops up in the future.
Shall we move on to the presentation given by Matt Gutwein, who represented Judge Fran Gull? Were there more things you wanted to say about Mr. Leeman's initial presentation?
I thought that covered it. So let's do Gutwein.
Okay. As I mentioned, Matt Gutwein represented Judge Fran Gull. And he started by trying to make 3 points. He said what Judge Fran Gull did was a use of her discretion. He said if Richard Allen believes that she did something incorrectly, he had other remedies he could use other than going to the Supreme Court. That he could have filed appeals in lower courts. And finally, his third point is by removing attorneys Rozzi and Baldwin, Judge Gull did not abuse her discretion.
Yes. And a lot of Gutwein's arguments seem to focus on process. Is this the right way to handle this disagreement? Is going to the Supreme Court the appropriate venue? And
he was trying to play to the justices a bit by saying,
yeah.
This isn't the way it usually works. And if you start letting people file these sorts of motions this early on in the game, you guys are going to be flooded with motions from defendants.
Have fun with that.
And I'm really worried about you guys having to work
One of the
hard.
justices was like, well, thanks for your concern about our workload, but, let's just hear it out. One thing that we've heard from attorneys is that writ of mandamus, that sort of strategy here is often frowned upon. That doesn't mean it's not going to work. It just means that kind of speaks to the process issues here, where he's saying, even if, not even taking into consideration whether there's any merit, but this isn't the way they handle things. This is like if I have a fight with my neighbor, we don't go out and do a duel. We maybe go to small claims court. And so what he's saying is that this shouldn't even basically be a contender based on those issues alone, about Richard Allen's claims not rising to the level, and that he didn't go through the approved steps, and that there were other options that could have happened at a trial court level or with an appeals court that should have been done first before this.
I also thought a justice pretty early on in Gutwein's argument made a very good point. He said that Judge Gull indicated that she removed the defense counsels because they were ineffective. But is it possible that things are being conflated and that she really removed them because they were insubordinate? In other words, they were flouting her orders and her point of view. There was a gag order that she believed they weren't respecting. Didn't believe they were respecting the protective order around discovery materials. So even if we grant that what they did was insubordinate, does that make them ineffective counsel?
And I think what's important with that is, I think with ineffective counsel, there's perhaps a path to removal, or at least in more people's view, there's a path to removal. With incompetent counsel, with conflict of interest, there's a path to removal. But I don't like the way these guys are lawyering. Maybe I think it's the dumbest thing I've ever seen. I think it's an embarrassment. But your opinion doesn't really matter there, and certainly not to remove somebody. So what they're raising there, what the justice is raising there, is like, and I think he even said, I can understand not being happy with them, but does that rise to the level of, and then therefore they should be kicked off? Because that should be something that's reserved for, obviously, specific instances where that can be backed up with the law.
And they said judges have very limited rights to tell people who their attorneys can be. It's almost like, imagine that you have a friend you're very close to, and they choose a spouse that you think isn't good enough for them. That's basically your friend's decision. You don't have the right to step in and say, no, your spouse should be somebody else. Or if you do, you might get some blowback.
Right. And again, it's not really, one thing I think that's important is, I think the outcome of this is not really going to be, people are going to read it, obviously, however they want to read it. People are going to read it as an indictment of either the old defense attorneys, or a vindication of them, or an indictment of Gull, or a vindication of Gull. I don't think the justices really care about the legal egos here. I think the justices care about, how do we get this case back on track? How do we protect Richard Allen's rights and safeguard the entire case? So what it's going to be is not necessarily if Gull comes back, if Gull stays on, I don't think this is necessarily them saying, wow, this was the best way to handle this situation. Great job. I also don't think that if the old defense attorneys come back on, it's necessarily saying, wow, this Odinist theory, that's artwork. Love that for you guys. Great job. And that leak, no big deal. I think they're being handed a whirlwind in a bottle, and they're just trying to friggin' open it up without destroying the whole house. They're just trying to figure this out and do the least harmful thing at this point, because the amount of egg on people's faces in this whole mess is
staggering.
Yeah, we're like, this is like a fight in a house of omelets. It's a mess. The only person who's not directly implicated at this point is Nick McClelland. And I just think the whole thing has just been, and I guess the new defense attorneys, in fairness, they've done one thing. They did one filing, but I mean, so far, just the fact that this has devolved into this like stupid death battle between the judge and the old defense team, and that things have been derailed to this point.
It's like a fight in a house of omelets.
It's like a fight in a house of omelets. Egg on the face.
I don't know what that means, but it seems appropriate.
I guess I'm just like, this is like, my heart goes out to these families watching this. I mean, this is supposed to be a process where things move along methodically, and things are not happening that are unprecedented, bizarre occurrences that throw everything. And then that just happens on a weekly basis in Delphi, it seems. So I just feel bad for them. This isn't really how the process is supposed to be working. The fact that we're in the Supreme Court right now indicates that it wasn't working, and something happened that was wrong, or something happened that was questionable enough to raise concerns. And it's a mess. That's just my opinion, but I think it is a mess.
The justices returned to the point more than once about how Gutwein seemed very concerned with the procedural questions of whether or not this should have been brought to the Supreme Court, or should have been brought to other courts first. And they're like, well, we're hearing it now, so why don't we just not even worry about the procedural stuff and discuss it on the merits? And he says, oh, no, we should talk about the procedural stuff. And I think the way to think about that is attorneys don't want to give up any argument that might help them win. And if he can win on the procedural argument, then why even worry about other areas of argument? It'd be like if I told Anya, I really, really want a new car because I think it would be easier for me to go to the grocery store. And she says, Kevin, the grocery store is right across the street. You can just walk to the grocery store. And I said, well, it'd also be easier for me to go to trial, which is like, so it's like if the first argument works about the grocery store, I'm done. But if I need another argument, I have one in the bank.
Yeah, but it makes sense to try the first one because it's like kind of easy, or like
Or if for some reason I have to present my reasons for buying a car to Anya and perhaps her sisters, maybe Anya is persuaded by the grocery store argument. Maybe one of her sisters is persuaded by another argument. But if they both agree, well, Kevin should get the new car, that's all that counts.
It's a weird matriarchal family structure in this situation, I guess. The Council of Sisters. Yeah,
the Kane Council.
It makes sense in terms of how how I mean, a lot of the arguments with Leeman and with Gutwein were like that, where you're like, okay, the general public might see this and be like, this guy's being real stubborn. But there's a reason, and there's a legal reason, and there's also a strategic reason of not wanting to give ground. So it's not necessarily like, I mean, like, you kind of almost are like, wait, yeah, that makes sense what the justice is saying. Why don't you agree? And it's like, they're not going to be like, oh, gosh, yeah. Wow. I don't know what to say to that. You're right. Pulls collar.
Since we actually, as I mentioned in the beginning of the episode, we watched this separately. We weren't together. We haven't really had a chance to go through all of our notes together. There was one moment in Gutwein's argument which struck me as a little bit humorous because it's like he caught himself just in time.
Uh-oh.
This was when I'm curious if this jumped out at you as well. This was the argument they were making, where they were suggesting, the justices were suggesting, why wasn't there a hearing? Why wasn't there more notice of this? And he was trying to argue back, well, obviously, even though there wasn't a formal notice of a hearing, they were aware of what was going on. They saw the tea leaves. They knew what Judge Gull was saying, that she was considering taking them off. And surely they realized that because they're highly competent lawyers. In other contexts. Because, of course, one of the arguments is that they're not good enough attorneys to be able to represent Richard Allen.
Right.
So they're highly competent for this argument, but in other arguments, maybe,
Yeah, they're bubblers.
So he caught himself there. Did you catch that?
I picked that up. I guess I saw it more of like, maybe, I don't know, trying to be nice to them, like, and like their experience, they're seasoned, but they badly bungled this. But I think I like your interpretation of like, whoops, can't compliment him too much. Yeah, I think for me, Gutwein did a good job. In terms of like being, he seemed more, more down to earth, maybe a little bit more clinical, a little bit cooler headed than Leeman, who was more passionate. That was just different styles. There's not really one that's good or bad. I think it comes down to personal preference. But he was more legal, procedural, things like that. The other guy's going on more about the injustice of the matter. I would say though, one thing I talked about, areas where I felt Leeman kind of had a hiccup. I felt Gutwein's big hiccup for me was,
I think I know what you're going to say.
Oh, you know what I'm going to say. Wheat. Wheat. He loves wheat. And I don't mean bread. What are we talking about here?
There's a court case, the wheat case, which he believes completely supports and validates his position. And so he mentioned it a lot. And a couple of times, I believe it was Justice Rush who said, I don't read this case quite the way you do. But he still kept on talking about
I don't want wheat. Do you have any rye, barley, quinoa, wheat? He couldn't get off of wheat. And that made it look like, that made it look like then, oh, you don't have another case to support you. You're just obsessed with wheat. So I think that was where he had a hiccup. And she also indicated, listen, I get what you're saying about wheat. I don't necessarily agree with your reading on that. I think you're reading it too strictly. And so what do you have to say to that? What I have to say to that is wheat. So there was too much wheat. And I think they got a gluten allergy or something. I don't know. I don't really know what's in wheat. I'm not a nutritionist. Ignore me. But I think they really were very much, there was too much wheat. And I I think the justices noticed that, and they even called it out. So that was, to me, the area where he seemed to kind of show more weakness in that.
Another thing that came to my mind is anyone who's been in law school knows the horror of being asked hypothetical questions that could potentially make your position seem weaker. And one of the justices asked Gutwein a hypo that I frankly think he largely tried to dodge, which is, what if the situation was reversed? What if prosecutor Nick McClelland, what if his office was somehow implicated in the leak of crime scene photos? Would a judge have the right then to disqualify those prosecutors?
Right. What? Yeah.
What's good for the goose is good for the gander. If you can disqualify defense attorneys for doing X, shouldn't you also be able to disqualify prosecutors for doing X? I thought he kind of ducked. He said, "Yeah, we don't need a rule.
Doesn't need to be a hard and fast rule." Yeah, I thought he did too. Although, just bouncing off of that, I remember at one point Leeman was talking about, the prosecution has leaked stuff too. Essentially, he was putting out an accusation there, and that is not something that we've seen any evidence for. And so I was surprised that he said that. Did you get what he was trying to do with that? Like, I'm trying to make sure I didn't misunderstand him.
I don't recall Leeman saying that. I remember some justices saying there've been allegations of that.
I thought Leeman brought that.
Maybe in the briefs. That's possible.
I thought Leeman brought that up. I thought he was basically saying, well, it's been done before. When?
I'm not aware of any leak like this happening from the prosecution side. Or I'll go even further. I'm not aware of any.
I'm not aware of any leak like this happening, period, in the case. And I mean, people can conflate things like Keg and Klein, us getting those documents. But first of all, that was a glitch. And second of all, that's a different case. In this, people sometimes just get on the internet and just say things. And I'm like, is that where they're getting their information from on that? I don't know. Because if there was another leak, where, I would think they would be including that in more detail and giving a context about what the heck they're talking about. That baffled me that they included that. Now, I want to go back to the hypo, as you called it, in their little lawyer slang. Can you tell our audience about, because this always made me laugh, you talked about you were the subject of the law professor's attention and kept on getting, what did they get you to agree with?
Oh, yeah. I know what Anya wants me to talk about here. So when you're in law school, you start off by arguing you read cases, you tell the instructor what you think it means, and then in front of your class, the law professor will ask questions which eventually run the risk of getting you to concede ridiculous points. And this is what might potentially happen in oral arguments if you're not wary, because justices and law professors love doing this sort of thing. It was a question, the case he was talking with me about, again, in front of 50 or 60 people, involved self-defense. And he got me to suggest that maybe if you were on a dog sled being pursued by gunmen.
Sorry.
You would certainly, if you had other heavy things on the sled with you, let's say I had some bricks of gold or something like that belonged to someone else. If I threw them off the sled so I could go faster, we wouldn't really consider that theft if they belonged to someone else, because I have a right to protect my life. And I believe he got me to say that if you had babies on the sled with you, it would be self-defense to throw them off the sled, which obviously I don't believe in. It's ridiculous. But this is the sort of thing these professors and justices can do.
That's so evil. It just sounds awful. You just go into class and get embarrassed for an hour, or I don't know how long law school classes are. Oh man, I just always thought that was funny. It sounds like my personal nightmare. Yeah, just unrelenting questioning on both sides here, which again is appropriate. But, you know, some of the questions took on a level of sass and feistiness. But again, not surprising. It's an important issue. They're really going to push hard. They're pushing both of these men around. And, you know, that was very much... I felt like some of the questions against Gutwein took on a more pointed quality, though. And basically what you had was what we heard from Chief Justice Loretta Rush, is that she's concerned about structural error. She cited that and indicated a number of times, like, I get what you're saying, but I'm what I'm having trouble with is X with Gutwein. And so I felt like you certainly had similar statements when it came to Leeman, but it seemed like there were some really my ears perked up when she started saying structural error. I'm like, yeah, you know, like that's like a red alert, because that's obviously what they don't want.
And then we would be remiss if we didn't mention that there was another attorney arguing today. This was Angela Sanchez, who was a representative of Indiana's Attorney General, Todd Rokita. She argued from the same side as Matt Gutwein. So it was, I think, essentially to let the justices know what side the state of Indiana was taking in all this.
So Ms. Sanchez was kind of representing the state and representing Todd Rokita's office. They didn't really go as far as Gutwein, in my opinion, but they were just sort of there to say, we generally agree with him. Maybe we have some concerns, but we generally agree with him. That was kind of what they were speaking to, but she didn't really have a lot of time in there.
Yes. And so when Mr. Leeman spoke initially, each side gets 30 minutes. He spoke for, I believe, 23 minutes and saved 7 minutes for a rebuttal. And then he came back at the end of the hour to give his 7-minute rebuttal, which was very powerful, very well done.
Yeah, he did a really good job with that rebuttal. He seemed less shaky. Not that he'd been shaky in the first part, but he was, you know, there was points where he was stumbling more. I felt like the rebuttal was very much his opportunity to kind of really bring it back, reiterate his points in a forceful way, maybe clarify some things for the justices that they'd been asking. And I thought he did a very good job there.
Earlier, the other attorneys said, oh, we're not really sure what Richard Allen wants in all of this. And in his rebuttal, he said, no, we know exactly what Richard Allen wants.
Yeah, he's written us letters about it.
And he was very, very forceful and persuasive.
I think it was very persuasive. The skeptic in me is like, well, but this actually, to me, is actually a point for the defense. The skeptic in me is like, well, does he really know? I mean, he got Rozzi's side of the story. How much did he really tell him, or did he shade it in a way? Like, has he had the clarity and the time to really process and kind of get some different opinions? But the way you deal with that is you have a hearing where you can hear all that. So I think that still ends up being somewhat of a point for the defense, because it's like, if he's not really sure and he's getting kind of sold a bill of goods by Baldwin and Rozzi, then the way to get around that is to like have things more on the record. You know, and it's not to be like, oh, well, just here's some new guys. So, I mean, that's just my opinion.
During the rebuttal, he was asked by a justice a pretty interesting question. They said, do you basically just want Baldwin and Rozzi to be reinstated? Does it matter to you if they are reinstated as public defenders or if they're reinstated pro bono? And what that means is if they're reinstated as public defenders, that means the state would pay their fees. And if they're reinstated as pro bono, it means they would work for free. And they said, does it matter to you as long as they're reinstated? Does it matter if it's pro bono or public defender? And Leeman said, well, pro bono would be more of a half measure. And after all of this, to put them back on the case and make them work for free would almost seem like a punishment.
Mm-hmm. Well, it would be a pretty punishing ordeal, I imagine, because it would be opportunity costs along with not getting paid. So,
he also made the point, Gutwein talked a lot about wheat, Leeman said, weed isn't even about this. Weed is about conflict of interest. It's not about ineffective counsel.
One thing that struck me about the pro bono thing, though, is that one thing we've consistently heard from attorneys who are both former prosecutors and former defense attorneys who have nothing to do with the case, but are just, know about this stuff, is that it is much easier to remove people for being, public defenders. A sticking point is pro bono. A lot of people who we talk to and say, hey, what do you think of this situation that's going on in Delphi? They'd be like, ooh, well, I could see kicking them off as public defenders, but I don't know if you can do that pro bono. And that's something that it just interested me. That was one of the last questions that the justices asked about, because again, that's been a sticking point that you can get rid of them as public defenders, but can you get rid of them if they're his counsel of choice and they're doing it for free? And I mean, that's what he wants, right? Because then they're retained. I mean, they're not retained in the sense that they're getting paid, but they're retained otherwise. Can we talk about the different options of what could happen quickly, and then talk about what we think is going to happen, or at least what we, think may happen?
I'd love to hear you predict what you think is going to happen. I'm not going to do that.
Oh, why? Oh, you're no fun.
There's a variety of options.
I'm not going to talk what I think is most likely. I'm going to talk about what are the options, and perhaps what I'm getting the sense is the consensus from legal minds that we consult with.
Okay. For the sake of this discussion, let's leave out the question of whether or not they are going to grant a speedy trial.
Yeah, because that's a side. That's the important things are judge go, defense attorneys go, come back.
Okay, so one option is the judge decides to bring back the defense attorneys and has them be public defenders, meaning they're paid for by the state, and kicks Judge Gull off. They could have the defense attorneys come back pro bono, meaning no one pays them, and Judge Gull is kicked off. They could keep the defense attorneys off the case and keep Judge Gull on the case. They could keep Judge Gull on the case and keep the defense attorneys on the case and say, what you need to do now is bring the defense attorneys back and have a really in-depth hearing on all of this and create a record.
Yeah. Could they just wild card it and they're looking at everything from 1,000-foot view, so that just us tiny humans on the bottom have emotions but they don't, and make up with each other? You're all back on.
They could, but I think if they did,
it would be a bad idea.
I think there would need to be some kind of hearing to establish whether or not these men were ineffective counsel.
Right. Is that basically all the options?
Because they didn't really get into the merits of whether or not Rozzi and Baldwin actually were ineffective. Basically, they focused more on the process. Was it handled correctly? And even if we assume they were ineffective or negligent, does it rise to the level they can be taken off even before a trial?
That's what I said. This is less a referendum on what Rozzi and Baldwin did. It's more of a referendum on what Judge Gull did. But generally, it's ultimately what the law says and what they feel is going to be the most destructive or least destructive path forward for Richard Allen's rights. Ultimately, it's going to rise and fall with that. So that's why I encourage people, don't see it as necessarily oh my God, they think these guys are great, or they think she sucks, or they think she's great and they suck. It's more complicated than that. It's more cerebral.
And I've said this before, and I apologize for repeating myself, but we also need to keep in mind that all of us care really deeply about the Delphi case. And so we're looking at this as what is best for this case. And you may have the feeling that maybe they should come back and that's best for the case. Or you may have the feeling that they need to go and that would be what's best for the case. But what the justices need to consider is how would this affect other cases going forward? Because if they remove these attorneys and keep them removed, that would be a precedent which would allow other judges to remove attorneys for perhaps other reasons. It's like when you're dealing with a child and you give the child a little bit of a concession and they use that to pry a bigger and bigger concession out of you. And if you establish a precedent that, well, yeah, you can remove lawyers for reasons other than conflict of interest, maybe it's going to get easier and easier to remove lawyers.
Yeah.
On the other hand,
maybe it'll be easy to remove judges.
Yes. On the other hand, you could argue that maybe this would affect other cases because it would make it more difficult to remove lawyers, and that may embolden bad behavior. So they have to look at how is this going to affect every case in Indiana. Why you and I, and by you I mean all of us listening, we tend to just look at how is it going to affect Delphi.
Based on what we've heard from other legal folks who are not affiliated with the case in any way, who we just check in with and get their thoughts on stuff, I think that the old defense team is going to successfully come back. That's the thing a lot of people have said, that they felt that is ultimately the most conservative approach, because it's not about saying, okay, the leak is okay or everything they did is great. It's about what will be the least likely to end in a complete mess of an appeal down the road. And that's going to be something that the justices might care about, because they're looking at it in more of a forward-thinking, case-centric way than about like any one side. So I thought that analysis that was provided to us by multiple different attorneys was sound and makes sense to me as a layperson. I'm not saying that they're right, but I think that at the end of the day that it's gone this far, that they've heard the oral arguments, the questions they asked. I can see that happening. Do I think they'll come back as public defenders? Possibly. Do I think they absolutely will? The fact that they were asking about the pro bono thing at the end at least leaves the possibility in my mind that they'll be back, but maybe not on the terms that they see best. But that remains to be seen. Ultimately, that will depend on whether the justices think it was okay for them to be removed in the first place, or if the problem was that they were removed as pro bono, I guess.
And if that's where we close the book on oral arguments today, there was incredibly yet another development in the Richard Allen case today. And that is the fact that there were some potential amended charges filed. Previously, Richard Allen had been charged with 2 counts of essentially felony murder. This, of course, is causing a death during the commission of a felony. Now,
felony murder is not written out that way. It's not called felony murder in Indiana. It's all murder. It's just a different, it's a different subsection of murder here, just to be clear. But it's essentially meets the definition of felony murder as it's known in other states.
Yes. So now Prosecutor McClellan wants to amend the charges to the 2 existing charges of felony murder. He wants to add 2 additional charges of murder, meaning that Richard Allen intentionally killed the 2 girls. And then he also wants to add 2 charges of kidnapping. Kidnapping was the underlying felony referred to in the original charges.
A lot of people over time, including us, have wondered, why aren't there more charges? Why was it just felony murder? And so now because it's like, is that all they can prove? But this, to me, indicates that they feel strongly that they can prove all of it, the murder and the kidnapping separately. So it's a show of force on McClellan's part, in my opinion. I don't necessarily think it means they have new bombshell evidence, but at the very least, it means that conversations are happening in the background where they feel like we can go for this now. So it's interesting. Not really getting new information on the case, but we're at least seeing where the prosecutor seems to think that because before, all they have to do is prove that he kidnapped them from the bridge. What happens after that doesn't really matter. All you have to do is prove that he kidnapped them, and as a result, they died. But now they're saying, no, we can prove that he murdered them.
So it's an interesting development indeed. There was also a pre-trial hearing in the ongoing case of Mitch Westerman today. This is the man who was charged with making copies of crime scene photos he discovered in Andy Baldwin's conference room and then sharing them with others who subsequently shared them with still others and others and others. We were not able to attend that hearing because it was taking place just before the Supreme Court hearing, and the travel distance didn't work out for us to attend both.
Nope. But we'll keep you apprised on that case and all the different associated cases and topics with this going forward. Thank you so much for listening. We really appreciate it. And hopefully this discussion added some insight, context, maybe made you think some different things about the case and its recent developments. And we hope you enjoyed it.
Thank you so much. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.